Hello everyone and welcome to today's Mondac webinar in association with Swiss Legal Finance, who will be providing a comprehensive overview of third-party funding in Switzerland with a focus on arbitration, enforcement and asset recovery. My name is Dan Sampaio and I'm joined by a brilliant panel to take us through today's discussion. Ella Zimmermann has been managing Swiss Legal Finance for over 3 years and has successfully developed the company in the litigation funding market. As a qualified lawyer, Ella practiced at the Geneva Bar before joining Swiss Legal Finance. Sandrine Giroux specialises in domestic and international litigation with a focus on commercial and financial disputes, private client disputes, fraud and asset recovery, white-collar crime, cross-border insolvency proceedings, mutual legal assistance in civil and criminal matters, and international sanctions. Sandrine is currently President of the Geneva Bar Association and Senior Vice Chair of the International Bar Association Litigation Committee. Charles Adams is the former Ambassador Extraordinary and Plenipotentiary of the United States to the Republic of Finland 2015 to 17 and Global Co-Head of ORIC's International Arbitration Practice Group based in Geneva. Charles is acknowledged to be among the most prominent international arbitration experts in the world. He serves as ORIC's Global Director of Strategic Relationships. Before we begin today's webinar, a quick housekeeping item. You are able to submit questions to our panel by typing them into the questions pane of the toolbar on the right-hand side of your page, and we do encourage you to get those questions in. We will endeavour to answer as many as possible. It's now my pleasure to hand you over to Ella, Sandrine and Charles to begin today's webinar. Thank you.
Thank you so much for the introduction, and we're very happy to be here today. So I will first introduce you to third-party funding in legal proceedings and arbitration, and then Charles will talk more about arbitration, and we will close this webinar with Sandrine talking about enforcement and asset recovery. So thank you again for joining us today. First of all, the concept of third-party funding is still developing in Switzerland, and I really hope that this webinar will shed some light on the importance, in particular in areas like arbitration, enforcement, and asset recovery. So, as most of you know, probably, third-party funding is the practice where an unrelated party covers the cost of a legal case in exchange for a share of any financial recovery. Although this type of funding is still quite new in Switzerland, it is very well established in common law countries, and this is mainly due because of the high costs of litigation and arbitration, and also the frequent use of class actions. So to start, I want to provide you with a bit of context regarding legal framework for third-party funding in Switzerland. So this practice has been recognized by the Swiss Federal Supreme Court since 2004, so 20 years ago. And in 2014, the Federal Supreme Court went even further, ruling that lawyers have a duty to inform their clients about these funding options. So this legal background is important because it shows a clear acceptance of the activity in Switzerland, positioning it as a valid alternative for clients seeking justice but lacking the resources. So our mission is to provide access to justice for companies and individuals who have strong cases but who are unable or unwilling to fund their own litigation. What is important to know is that we can intervene at any stages of a case, so before the dispute arises, during appeals, or even in the enforcement phase. It's also important to note that disclosing the funder's involvement can even strengthen negotiation, reducing the likelihood of the defendant exploiting the financial limits of the plaintiff. So once we have approved the funding, the client will no longer have to pay anything, and SLF will pay all the legal costs. This includes the court costs, the lawyer's fees, expert fees, or any other costs needed for the proceedings. And it also covers the respondent or adverse costs if the case is lost. It's also important to know that SLF is only remunerated in the event of a win. And there are two models of remuneration adapted to each case. Sometimes it's also a combination of the two. The first is a percentage of the recovery obtained. And this percentage is typically adjusted to the complexity and risk related to the case. And the second method is based on a multiple of the capital invested in the case by the funder. So for us to provide funding, we need several criteria to be met. So first, the merits of the claim. We review the strength of the claim and the evidence, as well as the likely defense and counterclaims to predict the likelihood of success. Then the value of the claim must be at least 3 million Swiss francs. Regarding the litigation budget, we will target a ratio of 1:10 between the amount of funding required and a realistic recovery from the outcome of the dispute. Then to ensure the success of this funding, it is also important to ensure a proper alignment of interest with the client, with the claimant, and to approve the legal strategy. Of course, we try to avoid proceedings that tend to drag on for years, but we cannot predict everything, but it's something that we look at already at in the first analysis. And then it is important that the opposing party has the means to pay in the event of losing the case and to know how we will recover the gain. We can fund in almost all areas of law as long as there are financial damages. So typically commercial and contractual law, but also economic criminal law. So any proceedings for breach of trust, disloyal management, fraud, but also if the client's assets are seized, we can provide funds so that he can defend himself. In civil liability, it's a typical case of David against Goliath. It's litigation against insurance company, for example. And one last example that is important in Switzerland is inheritance law. So for example, an heir who is entitled to a share of the estate, but is in dispute with the other heirs. So virtually he has a lot of money, but in reality, he or she might not have the financial means to fight the others. Now, I would like just to walk you through the typical third-party funding process, which can be broken down into 6 steps. So first, we have the initial submission by phone, email, or a meeting. It's a summary of what the case is about, the value in dispute, the enforcement strategy, anything to give us a bit of context on the case. At this moment, we signed an NDA and proceed with the conflict check. After the signing, we do the first analysis of the merits of the case, so all the criteria I mentioned earlier. If this initial assessment is positive, we then draft a funding agreement. And as soon as this funding agreement is signed, we proceed with a second analysis that is more detailed on the facts and law, on the quantum and the enforcement of the judgment or the award. And this step involves external experts. Always. And the final decision is then made by our investment committee that is composed of experienced professionals. Of course, there are a lot of advantages for plaintiffs and lawyers to obtain third-party funding. I think the biggest one for plaintiffs is access to justice without the financial risk. And what I like to ask plaintiffs who are a bit hesitant on contracting with a third-party funder is, do you want to bear 100% of the risk for potentially 100% of the reward? Or would you prefer zero risk for a smaller share of the gain? Typically, this question works pretty well, and claimants prefer to reduce their exposure to risk. For the lawyers, the benefit is also the ability to conduct complex case with confidence that their fees will be paid. And the lawyers will also have access to the experts that we mandate to provide in-depth analysis. So that's also a big advantage. Regarding arbitration, third-party funding is especially relevant in this topic because, of course, that's also how it started. One of the reasons is the costs of our arbitration are pretty high, depending on the institution that handles the arbitration. So we try to help leveling the playing field, making it accessible, especially for claimants who would not be able to pay these kind of costs upfront, because a lot of costs are due from the beginning of the arbitration. In international arbitration rules, such as the ICC rules or the IBA guidelines, they often require the disclosure of funding agreements to avoid conflicts of interest. This is not the case in Swiss rules for the moment. And also under Swiss civil procedure, there is no requirement to disclose the existence of third-party funding agreement. We will have a more in-depth analysis on arbitration with Charles after, with a specialist, so I will not give too many details on that. The role of the funder is also very significant in enforcement and asset recovery, because once an arbitral award or a judgment has been obtained, enforcing it can be complex and costly, especially when dealing with cross-border issues. And sometimes the claimant also has financed the whole proceedings, but lacks the means to finance the enforcement. And that's where we provide the necessary funds to pursue this enforcement, ensuring that the financial burden does not fall on the plaintiff. And Sandrine will also talk about enforcement proceedings in Switzerland, and I will let her give her expertise on that. Regarding the regulatory developments in Switzerland, there is a growing momentum for authorizing class actions in Switzerland, but those changes are still being debated in Parliament, and they did not make it into the recent update to the Civil Procedure Code. In this updated version, which will come into force on January 1st of next year, there are two interesting changes to third-party funding. The first one is that the government will now be required to inform plaintiffs of the existence of such funding, and the courts are also required to reduce their advance costs by half. So this is the amount that plaintiffs have to pay to the court before the litigation begins. So these factors indicate an increased awareness of third-party funding and the opportunities arising from it. So we really hope it continues to develop here in Switzerland. And now to conclude, I just wanted to point out that it's nice to see that Switzerland is becoming more and more attractive for third-party funding by offering, so we as third-party funder, by offering an alternative to self-funding and insurance, we empower the plaintiffs to pursue their legal claims without facing overwhelming financial obstacles. As Dan said, we will have questions at the end, so I will let Charles proceed with the arbitration focus. Thank you.
Thank you, Ella. I'd like to talk about Geneva as a place of arbitration and the importance of the arbitration industry to Geneva and to Switzerland in general. I'd like to start by pointing out that the very first international arbitration proceeding ever held was in Geneva, and it was in the year 1872. And it had to do with a claim by the United States of America against the government of Great Britain for the damages that were created by the depredations of Confederate warships during the American Civil War that were built in Great Britain and were more or less commissioned by the British to prey on shipping of the Union states during the Civil War. And so after the war, there was an international arbitration, and the seat of the international arbitration was Geneva. And today in Geneva, there is in the town hall a room called the Alabama Room, in which these proceedings were held. I have a particular personal interest in the history of these proceedings because the tribunal was composed of 7 individuals, including one American. And the American was a fellow by the name of Charles Francis Adams, who was a prominent American diplomat at the time. He had served as ambassador of the northern states of the Union to Great Britain during the Civil War, and was on the panel of arbitrators in this Alabama damages case. He is an ancestor of mine, 3 or 4 generations removed, but it always makes me smile to see his name up on the board in the Alabama Room as having been an arbitrator in the world's first international arbitration proceeding. Geneva, in the years since then, has become one of the world's principal hubs for international arbitration. The reason for this, I think, had to do initially with the idea of Switzerland as being a neutral place and a place where parties with opposing points of view could come together in a context where the playing field was level and the proceedings would not be infected by some kind of home court advantage. The same is true, by the way, of Zurich, which competes with Geneva as a place of arbitration within Switzerland, just as Switzerland competes as a place of arbitration with traditional leaders, London, the London Court of International Arbitration, or the International Chamber of Commerce in Paris, and increasingly with institutional centers of arbitration in Singapore, in Dubai, in Brazil, and all over the world, because international arbitration has become a huge industry. It's been estimated that as the addition of the amounts in controversy, the amount of legal fees, the arbitration fees, the court reporter fees, the hotels, the restaurants, all of which are part of the ecosystem of international arbitration, represent something over $60 billion a year worldwide. And so this is an industry which attracts competition. Geneva likes to feel that it is a leader and is particularly attractive as a place of arbitration, not simply because of the neutrality of Switzerland in general, but because of the availability in Geneva of highly talented international arbitration practitioners, such as Sandrine and many other very, very capable Swiss practitioners, and a number of foreign law firms, such as my own, Auric, who have found Geneva to be a very attractive platform from which to practice international arbitration worldwide. In my case, I've been in Geneva for 38 years practicing international arbitration, minus 2 years when I was drafted into public service by President Barack Obama as the American ambassador to Finland, of which I keep an excellent souvenir, to such an extent that I don't exclude the possibility, depending on the outcome of the forthcoming American elections, of raising my hand for another such opportunity in the years to come. But otherwise, all I do is international arbitration. It needs to be emphasized that in my case, the arbitrations can have as a forum anywhere in the world. My office is in Geneva. I do my work from Geneva. My team is in Geneva. The International Arbitration Practice Group of the law firm is represented in 6 or 7 different offices of the firm around the world. And so quite typically, I would be working either as counsel or as arbitrator on a case which could be venued in Singapore or in Dubai or in New York. It truly is a global industry in that sense. It has a connection to Geneva because from time to time, the cases themselves can be venued in Geneva. But at all times, I and my team are working from Geneva, as are many of our colleagues in other firms in Geneva, specialized in this aspect of the practice of international law. I think there's one thing that's important to understand, to come back to some of Ella's comments with respect to Swiss legal finance. And that is that Swiss legal finance does not confine itself to doing third-party funding for matters in Switzerland. In fact, I'm persuaded that the bigger market for Swiss legal finance is going to be in third-party funding in international arbitrations that will be in Brazil or in Australia or in Singapore or anywhere in the world, because Swiss legal finance is not restricted geographically in the third-party funding service which it offers to its clientele. And I can predict with a high degree of certainty that in the years to come, an increasing proportion of the matters which are funded by Swiss legal finance will be proceedings that take place somewhere outside of Switzerland. I have a remark to make about the US as an increasingly unattractive place for international arbitrations to be venued. And why is that? It's because the Americans in recent years have become very difficult to deal with when it comes to simple visa applications, particularly when witnesses or arbitrators or the lawyers hail from countries which, for one reason or another, are on a disfavored list. And you know the places of which I'm speaking just as well as I do. So if it is impossible for an arbitrator to obtain a visa to participate in an arbitration in New York or in Atlanta or in Washington, D.C., it makes the U.S. an unattractive, in fact, an impossible place for the venue of an international arbitration proceeding. This to the great joy of the Arbitration Center in Canada, because it has found that its business volume has increased exponentially with the relative unattractiveness of either New York or Washington as venues for arbitration. Now, as I'm sure that anyone participating in this program is aware, the place of international arbitration, the venue, and the administering institution are all matters that are dealt with at the stage of the original contract negotiation. International arbitration is a private, contractual mode of dispute resolution, and so it is at the time that the contract is entered into that the matter of arbitration versus litigation is decided. In the event of arbitration, where, under whose rules, and under what conditions. Typically, in a contract negotiation, the arbitration clause is the last thing that is decided after 3 days of intense negotiation over price and terms of other aspects of the contract. But years later, when a dispute arises and the arbitration occurs, then in retrospect, it becomes extremely important that the parties have decided on Geneva, say, as opposed to New York or Johannesburg as a place of arbitration, or that they have chosen to subject the arbitration to the rules of the Swiss chambers, as opposed to the Dubai International Arbitration Center or the Singapore International Arbitration Center. It does make a difference because those rules are not all interchangeable. It happens that Swiss Chambers has the most modern, the most recently adapted, and the most flexible of the rules governing international arbitration proceedings. And parties need to be aware of the fact that they are free to adopt the rules of the Swiss Chamber, even for arbitrations, the place of arbitrations for which is Singapore or Dubai or New York or anywhere else in the world. It doesn't have to be an arbitration venued in Switzerland. So the same thing applies to the third-party financing of arbitrations, which doesn't have to be, in the case of SLF, in Switzerland. It can be anywhere in the world. And so the audience of participants interested in international arbitration as a mode of dispute resolution need always to keep in mind the universality of the discipline, its mobility, its agility, and the fact that it provides a mode of dispute resolution which is meant to be private and confidential, as opposed to domestic litigation, which is of public record the moment it begins. And this is why international arbitration still today represents an industry of extreme worldwide value. It is not without controversy. There is a school of thought which argues that international arbitration has become overly expensive, unduly complicated, burdensome, and from time to time arbitrary in the results that it reaches. And the end user community, which is the community of businesses which choose to provide for international arbitration or not in their contracts as a mode of dispute resolution, are asking more and more difficult questions of the practitioner community as to how we can do better at controlling the costs of the proceeding, of expediting the proceeding, and of making them cheaper, more efficient, and frankly, less from time to time arbitrary in their result. And so we have a lot of work to do. A lot of us in the community, which includes everybody who is following this conversation, need to work together to that end. And with that, I turn the floor over to my colleague Sandrine to talk about how we go about enforcing the awards that come out of these proceedings.
Thank you, Charles. You mentioned your role as ambassador, but I think you're certainly one of Geneva's best ambassadors, so thank you very much. And to pick up with what you said, that Geneva has a lot to offer. It was also not only arbitration, but now legal services and also Swiss law, which is one of Switzerland's specialty and one of its jewels. It's more the contractual side, but I wanted to mention it. And mention also an initiative that has been launched in Geneva to enhance Geneva's position as a go-to international hub for law and legal services. And it's called the Geneva International Legal Association. And I'll put the link in the chat for those who are interested. And you will know more about what you can do in Switzerland, be it arbitration, enforcement, and all these issues. But today we are focusing more specifically on asset recovery. And why Switzerland? It's a known secret that Switzerland is one of the largest financial centers. So when you're trying to enforce, you're trying to go after the money or you're trying to go after assets. And certainly Switzerland has a lot of financial assets. Switzerland has other jewels besides chocolate and cheese. We also have real estate, people who have nice chalets or nice properties. We also have luxury assets such as artworks, jewelry. Some of them are held in free ports, for instance in Geneva, which is sometimes said to be one of the most important art museums in the world, but the problem is no one gets to see the artworks. There are also some holding companies, and so holding different assets, entities and shares. However, you have banking secrecy, and you have no discovery proceedings. So you're completely in the dark when you try to find assets. So unless you have good investigators who help you trace those assets, or you have documentary evidence which can point you to some places, it is often difficult to identify assets against which you want to enforce. There are different ways to go about it. The obvious way is once you have a judgment or decision, you try to enforce it through civil proceedings, and I'll get to that. But I want to mention that one of the tools that we like to use as Swiss litigators, it is criminal law. I know this may sound a bit particular for common law lawyers, because you tend to really separate criminal proceedings from civil proceedings. But in Switzerland, as a civil jurisdiction, criminal proceeding can be very helpful when you're trying to recover assets. One, because the prosecutor has wide-ranging powers. He or she can order freezing with all banks. And there is no banking secrecy in relation to criminal proceedings. And what is particularly interesting is that as an aggrieved party, as a creditor, when you say you've been defrauded, you're a civil party in the criminal proceedings and you have access to the full file, meaning that you have access, for instance, to all the banking documentation, which you would otherwise have very difficult, great difficulties to get through civil proceedings. So if you have a case where you think there is fraud and then you meet the criminal threshold, it is often a tool, an avenue that we will encourage to consider in Switzerland asset recovery matters. Now, if we're talking in a more vanilla case, if I want to use that term, if you have a judgment of an award and you want to enforce it against Swiss assets, then you would have different steps to go through. First, you need to determine whether your judgment, your decision, your award provide for a monetary claim or a non-monetary claim. Is it about money or is it an order to do something? If it's monetary, we have one special procedure which provide that you could also request the attachment of certain assets in Switzerland. But for that, you need to identify those assets, and that is extremely important. That's one of the 3 requirements when you want to have an attachment in Switzerland. You need to have a ground for attachment, and an enforceable judgment or an enforceable award can be that. You need to identify assets in Switzerland. And I go back to what I was saying about the difficulty of tracing assets. For instance, you don't need to have the exact bank account number, but you need to identify the bank where the assets are. And you need to have a document or some evidence which can link the bank to the debtor. So these make sometimes the attachment exercise somehow difficult, but not impossible. I want also to come back to one of the conditions which I mentioned. It is you need to have an enforceable judgment or an enforceable award. This raises the question about world freezing orders, for instance. Can you enforce them in Switzerland or not? It depends who issued the order. It used to be pre-Brexit that UK world freezing orders could be enforceable to a certain extent in Switzerland under the Lugano Convention, because Switzerland is part of the Lugano Convention, which makes it easier to enforce Lugano judgment in Switzerland, and that was the case with England and Wales previously. But now, when you have a freezing order from England, you won't be able to enforce it in Switzerland because it is an interim measure. It is not a final decision. So those freezing orders are considered in a similar way as Cayman, BVI freezing orders, and would generally be rejected. I'm just going to address a few practical issues that come up in practice. I'm not going to give a full overview of the enforcement process, but just really focus on some of the obstacles that you can come across. One I'd like to mention is something that is often overlooked, is the limitation period related to a judgment of an award. And for instance, in the Swiss law, a Swiss judgment, can be time barred after 10 years. And in other jurisdictions, it can be about after 6 years or sometime less, sometime more. And so it is extremely important to keep in mind that even though you fought a very hard battle and you've got your judgment, it is important to validate it or to action it and not sit on it without considering the time passing. You really need to focus on that because otherwise you run the risk of having your judgment time barred. Another element, 2 other elements in the enforcement process in Switzerland which are important is due process, obviously, but this includes service. this means that the proceedings must be served properly. And in an age where you can serve now via social media and sometimes through the blockchain, you need to make sure that this service channel is recognized in the place where you want to enforce the judgment of the award. For instance, Switzerland requires that service is done as per the law of the domicile of the person who has to be served. So if you want to serve, if the debtor, for instance, is a Saudi national or Saudi resident, you need to serve him as per Saudi law. You can't just do it as under Canadian law, which would allow email service. You really need to go through that process, because otherwise, when you have your judgment, you run risk of it being dismissed. And I'm mentioning Saudi law in particular because we had a case where we were defending it and enforcement of a 1.2 billion decision from the Cayman. And the Cayman had simply advertised the proceedings in a local journal and sent a courier with the documents, and never bothered to formally, officially serve through mutual legal assistance channels, meaning in that case diplomatic channels. And when it came to enforcement in Switzerland, well, we had very fancy and complicated arguments to dismiss the case, but courts being courts, they tried to look at the quickest way to adjudicate the case, and they found a hole in the service process, and they said, well, you didn't serve as per the official diplomatic channels, and so they completely dismissed the enforcement request. And you can imagine that for $1.2 billion judgment, that must have involved a lot of costs in the trial process. And that was all this money which was almost went to waste, because you could not enforce the judgment in places where you would have assets. Another important point in enforcement is jurisdiction. You cannot simply go anywhere in the world and hope that you have your judgment and then you can go anywhere in the world and enforce it, particularly in Switzerland, because Switzerland will require that the jurisdiction which issued the judgment has jurisdiction under Swiss private international law rules. It means that it needs to be an indirect jurisdiction recognized by Switzerland. And in some cases, when you're faced with the interaction between common law jurisdiction and civil law jurisdiction, you may have different grounds for jurisdiction, and you may have gaps and sometimes overlaps. But it's extremely important when you try to litigate a case that you have the enforcement stage already at the forefront of your mind, already at the beginning, to ensure that service, but also jurisdiction, are bulletproof, so that when you come to enforcement, you don't have any issue. I want to mention one last point also, which is a Swiss specialty for good or bad reasons, is enforcement against sovereigns. When you want to enforce judgment or awards against states, Switzerland requires that you have a close connection between the claim and Switzerland. The rationale for that is that immunity is a matter of states and courtesy among states. And so one state will only go against another state, at least for Switzerland. Switzerland will only go against another state when there is a Swiss reason for that. And so there is a requirement that there is a close link between the case and Switzerland. And that can be because Swiss law applies to the claim, because one of the parties is Swiss, because there is a jurisdiction in Switzerland. These are all Swiss connections. And until very recently, there was a case that was saying that an arbitration with a city in Switzerland was not a sufficient link to Switzerland. However, in a recent case which we litigated, the Swiss Federal Supreme Court opened that door and said that we could not exclude a close link to Switzerland, meaning there could be one, in case where the seat of the arbitration, the arbitral tribunal, was specifically chosen by the parties to be Swiss. In the very earlier case, which dismissed this close connection, the issue was it was an arbitral institution which has imposed the Swiss seat. And in the most recent case, it was really the parties, even in that case, after the dispute arose, who chose Switzerland. And that showed that they wanted to have a close link to Switzerland. So again, when you have a contract or a matter with a sovereign or a state, it is also important to think about these elements to make sure that you could have a close connection in jurisdiction where you need one when it comes to enforcement. There could be a lot more to be said about enforcement, but I'll pause here, and I think we have a couple of questions in the chat and happy to address them if some are for me. Thank you.
Thank you very much, Sandrine and Charles, for this very interesting presentation. I saw that we have a few questions. Maybe I can start with the questions about third-party funding. I saw one that is also linked to arbitration, and I will read it out loud. Do you have to disclose to the arbitrators or the Arbitration Institute of such financing setup and its detail? To what extent? It depends on the Arbitration Institute. So, for example, ICC requires the disclosure of the presence of a third-party funder and also the name, but they do not ask for the funding agreement and other details on that matter. And this is for most institutions in arbitration, this is the requirement for now. It is not required under Swiss rules. And there are a few institutions where, depending on the case, they can also ask what is the financial gain for the funder, or if the funder is paying for the adverse cost in case the case is lost. But for now, the biggest requirement is the disclosure, just to ensure there are no conflicts of interest between arbitrators and the funder. I don't know, maybe Charles, add something? Yeah.
I have one comment on this, if I may. As you know, American lawyers are accustomed to operating under contingency fee arrangements, where the lawyer charges nothing unless the case is won. This is third-party financing in its purest form. Yet in Switzerland, it's illegal for lawyers to do cases on a pure contingency basis. And it's always struck me as curious that it should be illegal for lawyers to be third-party funders, in effect, in cases, whereas third-party funding as a concept has become recognized and acknowledged and legal and is prospering in Switzerland. So there's a little bit of a disconnect there that maybe Sandrine can explain, but it's always been something of a mystery to me.
Yeah, I think in the controls of Ellis, when you, as a lawyer, you have specific activities which are subject and regulated by law, but other activities that you can do, even though you're a lawyer, but you're not acting as your lawyer in your lawyer's capacity. For instance, if you sit on the board of a company, even though you're a lawyer sitting on the board of a company. So in that case, having a lawyer being a third-party funder would not be under the regulated activity as a lawyer, hence would not benefit from professional secrecy and all the other rights and obligations that would go with the lawyer's mission. But that raises one other issue, which could be also interesting, is the confidentiality of the information that you share as a client with a third-party funder, because one of the particularities of lawyer or lawyer's relationship is the professional secrecy, that you can share something with your lawyer and everything is confidential. So as a client, when you're sharing information with a third-party funder, you need to have an NDA in place, or at least make sure that the confidentiality issue is solved, because it doesn't flow from the law, because the third-party funder is not acting in lawyer capacity. And therefore, the restriction that you mentioned, Charles, quite correctly, do not apply in relation to a third-party funder.
So I would wager that Ella would very much like it if the lawyers conducting the arbitration proceeding, which is being third-party funded by SLF, themselves had some skin in the game and were prepared to operate at least on a partial contingency basis. Am I right?
Yes. Yes, well, that's something we start to see more and more, even in Switzerland, because it's possible for the lawyer to work for a reduced fee, and then have also a success fee at the end. So that's something that it can be very interesting in cases where the litigation budget is a bit short regarding the value in dispute, and it's also a way for lawyers to sometimes conduct bigger cases. So I think I understand the way Switzerland thought it would be illegal to make it 100% contingency fee, because then the argument was that the independency of the lawyer would be lost, because then the stake for the lawyer is also his remuneration, and it could be in conflict with the interests of his or her client. So I quite understand. And regarding the confidentiality, it's true that it's very important to have this NDA in place, and because we don't have the secrecy, like Sandrine said, but we can also be compared to insurance, for example, litigation insurance, that everything that we receive, documents from the lawyer or from the client concerning the case, is also covered by this confidentiality of attorney-client.
I can add one general observation on the future of international arbitration, and that is that the tragic events in the world today, with particular reference to the Russian invasion of Ukraine, with particular reference to the conflict between Israel and Gaza, are guaranteed to generate for the next 50 years all manner of disputes between suppliers and buyers and insurers and vendors that will fuel international arbitration for years and years and years to come. So it's very, very unfortunate that these events are occurring. We all would have preferred that the world be at peace, but in the discipline which is ours in dispute resolution internationally, there are going to be disputes galore that will extend way beyond my projected continuing career, and quite possibly that of my younger colleagues as well. So international arbitration is going to be a part of all of our futures.
Yes. Yes, for sure. One of the other question we had is the process time for to obtain funding. So it really depends on the complexity of the case. We try to do this process in 8 weeks, but of course, if it's proceedings with tons of documents, and if it also depends on the expert that we mandate for the case, but we usually try to do it in 8 weeks between the initial submission to the final decision from our investment committee. So, and if there is any legal deadline or things like that, we also take that into account if it's to make the process go faster. I think, Sandrine, there was one question for you at the end. I'm not sure.
Yeah, there are two. I think there's one on the enforcement about freezing order coming from the EU. Then such freezing orders would be recognized in Switzerland because EU and Switzerland are bound by the Lugano Convention. And in this case, even interim measures issued by an EU jurisdiction would be recognized in Switzerland. And coming back to freezing orders, we could think about Cyprus, for instance, which is a common law jurisdiction in the EU jurisdiction. So that could be one scenario. And I think at the end, there was one question about immunity and the close link, and whether having assets in Switzerland is a sufficient close link. Unfortunately not. You need to have assets, plus you need to have another special link.
Okay. Perfect. Thank you. Thank you for the answer. What other questions? There are a few. If I don't answer all of them, I will. You can always send it to me, and we can continue the discussion privately. That is also okay. What else did I have? Co-funding. Oh yes, I saw that Graham talks about co-invest, co-funding, and things like that. It's something that is developing a lot, co-funding between funders. So for example, if it's a case in Switzerland, and if we want to divide our risks by financing more cases, but with a smaller stake in each cases, we can co-fund the cases with another funder. Or what happens also often is a foreign funder who has a proceeding in Switzerland and then needs a local funder to lead the case because they either don't have the expertise, or they just think it will work better this way. So that's something we are interested, of course. And did I have another question? Oh yeah, do you fund only Swiss cases, or do you also fund cases outside of Switzerland? Yes, we also fund cases outside of Switzerland. Our expertise is in Swiss law, so we prefer cases with a Swiss connection to it. But as Charles said, in arbitration, it's also very, very different in international arbitration, because it then depends on the law applicable to the case, the seat of arbitration, and the institution. So yes, of course, we also look at cases abroad.
Ella, thank you very much for handling the Q&A session. We had a lot of questions in. As you mentioned, if we didn't get the chance to answer one of your questions, please do get in touch. I'm sure that our panel will be more than happy to answer any questions that you have offline. I'm just looking at the time. Unfortunately, we will have to wrap up there. It's been a really fascinating discussion with such a high-powered panel. We really appreciate your time, your expertise and insights today, an incredibly interesting discussion. I'd like to also thank our audience for being with us today. Ella, I will hand over to you for any closing comments that you might have, or indeed Charles and Sandrine as well. Thank you.
Thank you, Dan. Well, thank you very much for everyone who joined today. It was really interesting for us to have this webinar. And thank you, Sandrine and Charles, for being speakers on this webinar. We're really appreciative. Thank you.
Thank you.
Thank you, everyone. Charles, I think we have you on mute at the minute.
Simply joining in expressing appreciation to Montauk, first and foremost, for having made possible this most interesting exchange, and to our audience. Thank you for your questions. And there are a couple of questions that I've seen pop up as to which specific answers can be provided. Feel free to be in touch with any one of us. We'll be happy to continue the conversation. I'm sure you have our coordinates. We'd be delighted to have an opportunity to speak with you further.
Thank you very much, Charles. Brilliant. Have a lovely rest of your day, everyone. We'll see you again soon.
Thank you. See you again soon. Bye.